Right. I'm just trying to organize myself quickly. We have load shedding here and I had to change venues unexpectedly. So please bear with me. Just need a few minutes to organize myself. Actually, I am organized. Thank you. Good evening once again and welcome. I notice we are about 76 here now, which means there are quite a number of us still that need to log on. Okay, just to perhaps recap in the meantime what we did yesterday. Briefly, whilst the others find their way in, we dealt particularly with the action proceedings and the summons in terms of Rule 5, 6, and 7. What are the things that you need to put into your summons when you are drafting the summons itself? We also looked at how you cite parties in particularly summons proceedings, the description of those parties, and then we looked at some causes of action, which jurisdictional facts you need to plead. We also looked at interest rates and service of process by the sheriff. Today we are going to start with undefended actions. Now, when you are dealing with an action, we use the term the action is defended if there is opposition to it. If the defendant decides to defend the action, we say it becomes defended. And the difference between an action and an application, in an application, you will say that the application has become opposed. All right? So it's defended for an action and opposed for an application. Right, we are going to start with default judgment, which is a term I'm sure that you've come across. What does default judgment mean? Default judgment is when the plaintiff institutes legal action against the defendant or defendants, and that defendant does not defend the action within the time prescribed in the summons. Rule 12 is the particular rule that we will have to refer to in our rules relating to default judgment. And there it is specified how exactly you must apply for default judgment. In other instances, the defendant may file a notice of intention to defend the action, but then fails to file a plea within the time allocated for doing so. One thing you must keep in mind is that in all court proceedings, there are specific time frames within which things are meant to happen. And the one example will be the defending of an action. A defendant is given a specific number of days, court days, not calendar days, court days. By now you should know the difference. Court days within which to defend the action. And if the defendant does not defend the action, the plaintiff may apply for default judgment. Similarly so, after the defendant has filed a notice of intention to defend, the defendant has to file a plea within the specified time. And if the defendant does not file a plea within the specified time, after having filed a notice of intention to defend, the plaintiff may apply for default judgment or judgment by default, as it is also called. I see a hand up.
Yes, Mr. Advocate. Just where you are now, I just wanted to understand. Is it mandatory for plaintiff to do a notice of bar when the plea has not been filed or served?
Yes, before you apply for default judgment, when a notice of intention to defend has been filed, you must serve the plaintiff must serve the defendant with a notice of bar, giving him or her 5 days within which to file a plea.
Oh, okay. Because I heard you saying that if that 20 days lapsed, and then one can apply for a default judgment. So I just wanted to understand, is it compulsory for the plaintiff can apply for a default? Is it compulsory for the notice of bar?
Now, you see, sir, you jumped the gun there, because that was going to be what I was going to say next.
Okay, no, it's fine. You can just
not
continue.
done yet.
Thank you. Thank you. You can just continue.
Thank you. As the gentleman has correctly said, when the defendant has not filed a plea within the prescribed time, the plaintiff serves on the defendant a notice of bar, giving the defendant a period of 5 days within which to file a plea. And if the defendant has failed to file a plea, if it is an illiquid claim, the plaintiff may apply for default judgment against the defendant. In the case of, I'm also going to deal with summary judgment now. Yes, sir, your hand is up.
Hello. I just want to find out, I know this is to do with the legal practitioners. What if the defendant is a layperson and he does not know about filing of pleas and drafting of documents? What happens in that case in terms of the court process?
If the defendant has chosen not to engage the services of a legal representative, then the normal course will run. The plaintiff may still apply for default judgment if the defendant has not employed the services of a legal representative and has not filed an appearance to defend and has not filed a plea. The plaintiff is entitled to proceed in terms of the rules.
But in that scenario, will the defendant be subpoenaed to court to stand there like a normal court proceedings and defend himself?
For purposes of the topic that we are dealing with today, if a defendant is in default of having defended the action and of having filed a plea despite being served with a notice of bar, the defendant will not be required to come to court in these instances because he is in default of having filed papers, and the plaintiff will apply for default judgment in his absence or her absence.
Okay, thank you, Advocate.
Pleasure. So as I was saying earlier, after the defendant has filed a notice of intention to defend, but has not pleaded within the time prescribed in the rules for pleading, the defendant must serve a notice of bar on the defendant. In other words, forcing him to plead or reminding him to plead within 5 days. And if the defendant fails to plead within 5 days, the plaintiff may then apply for default judgment against the defendant. And default judgment is applied for without notice to the defendant, because the defendant has been given ample opportunity to defend the action and to file his or her plea. Now, coming back to the issue of representation. If a defendant decides to represent him or herself in person in an action, that defendant effectively steps into the arena of the rules of court as well as the legislation that applies. And that defendant will be subjected to the rules and the conduct of the court with regards to that matter. Many defendants have, many laypersons have tried to defend themselves because they at one stage did a legal subject, or because they have a relative who once studied law and they think they can represent themselves. And that has been the biggest mistake, because the court, although the courts are sympathetic and assisting to laypersons, it is not advisable for a layperson to represent themselves, because they will not be able to conduct their case with the same proficiency that a legally trained person will do so. So when the plaintiff now applies for default judgment, in the magistrate's court, it's referred to as a request for default judgment. It's also called an application for default judgment, but it's basically semantics. You will not be turned away if you term it an application or a request for default judgment. But in terms of the forms that are at the back of your rules, there is also a blank precedent there for you to look at, called a request for default judgment. So default judgment, you must know when default judgment may be requested. For any sum which does not exceed the amount claimed in the summons, or any other relief claimed in the summons. You may also claim the costs of the action, as well as interest at the rate specified in the summons to the date of payment. And we said it's in accordance with the prescribed rate of interest at the time, which we established last night to be 10 rands at 10.75%.
Am I the only one not hearing?
No, I'm still here. I'm just adjusting my fan here because the very hot in this venue. Hello? I'm still here. I've not left. I'm here. Sorry about that. I was just adjusting my fan. It's very hot here in this venue. Apologies for that short break in transmission there. Now, one of the things that I did not touch on yesterday was that if the sheriff, in another way of serving summons upon a defendant is by way of registered post. And where summons has been served by registered post, you may then not apply for default judgment where that defendant has failed to defend the action if you have not attached proof of the registered post. Right? But registered post is an exceptional way of serving summons on the defendant. It's only if you only have a postal address for them and not a physical address, then you may make use of, because the sheriff can't serve on a postal address. Then you may serve by way of registered post. But it's very rare. I have not come across such a scenario where I've had to serve, cause to be served via registered post. So you need not worry much about that one. All right, so we know what is an unliquidated claim. And then once again, when you do a request for default judgment, you must stick to the rules, the basics of pleadings, as we said in terms of Rule 7. You have to make use of the heading in the magistrate's court for the district of or the region of, held at, and you must state where, because some districts have got specific venues other than the main venue, and not all magistrates courts are regional courts, regional divisions. Then you put the names of the parties on the document. The case number is important. You must put the case number on so that you're able to identify the document. And if you are represented as the plaintiff by a firm of attorneys, the firm of attorneys need put their name on there with their address, which is within 15 kilometers of the courthouse, as well as their contact details. I see a hand up.
Advocate, I want to find out these case laws that that's is that for exam purposes, is it very important for us to know all these case laws?
Yes, case law is always important for exam purposes because the legal principles are embedded in those cases.
Okay, thank you.
And you are required to read those cases during your own time. I will touch on some of the important ones here and there where I think it's necessary. Was there another hand up? Thank you. Then we'll proceed.
Yes, there's another hand. Sorry, Advocate.
Yes, sir.
Yes, I wanted to ask with regarding to when you serve with a registered mail, which one is important? The date that you have on your receipt of the registered mail, or the day that they've received it as the defendant, or
how are you going to know when they've received it?
Sorry?
How are you going to know when they've received it?
Yes, hence I want to ask, maybe if there's like a prescription that is maybe tomorrow, if I send it today, and probably fast mail will take like maybe 24 hours, and maybe the normal mail will take like 2 to 3 days. Is it important that I just send it with the fast mail, or should I send it with any mail? Because what will be important will be my receipt or their receipt.
Okay, in terms of practice and the rules, well, in terms of case law, there's case law that says that after the date of transmission of the letter, the mail to the post office, it is presumed that the registered slip will be received by the person for whom it is intended within 4 days of such postage. So you count 4 days after the registered post, and then after the 4 days of the registered post, you count the DAs in terms of your summons.
Thank you.
Are you satisfied?
Yes, I am. Yes, I am.
Thank you. An unliquidated claim is a claim in which the amount claimed by the plaintiff against the defendant is not an amount which is easily ascertainable in monetary terms. In other words, it is an amount still to be determined. And I will make an example. Where a plaintiff is suing the Minister of Police for an unlawful arrest and detention case. The plaintiff claims an amount of 5 million rands. The law on unlawful arrest and detention is being developed on a daily basis. The quantum which is awarded in cases of that nature changes all the time because of different courts. Some judges may find that a plaintiff is entitled to 25,000 rands per day for incarceration as a result of unlawful arrest and detention. Another judge may find that because the person who was arrested was a medical doctor, was embarrassed by it, an amount of 50,000 rand per day is justified. In another case involving an attorney who was arrested and detained for 4 hours, the court awarded an amount of 26,000 rands. So the amount fluctuates all the time depending on the circumstances and the personal circumstances of the plaintiff involved. So the 5 million rand claimed is an unliquidated. Let me start over. The 5 million rand in the example that I made with regards to unlawful detention, arrest and detention, is an amount which is estimated. It is not liquidated yet because the final award is not known. The court may find in that case that an amount of 80,000 rand will be sufficient. Only at that stage will the claim become liquidated. The award or the judgment which states at the end thereof that the plaintiff is awarded 80,000 rand as damages for unlawful arrest and detention for 3 days. And this is only an example. That judgment then becomes a liquidated document, and the amount becomes liquidated because it is certain. It is stated with certainty. So if the plaintiff sues a defendant for 900,000 rand for goods sold and delivered and uses an invoice or a statement of account as proof thereof, the statement of account or invoice is the liquid document because it has a certain amount which is ascertainable in monetary terms. That is referred to as a liquid claim. I cannot simplify it any more than that. So you then draft your request for default judgment. You copy it in duplicate or triplicate. Off you go to the court. Go to the registrar's office if it's the regional court. The district court registrar if it is the district court. You will then hand the document to the clerk in triplicate, and then they will tell you to return on a specific date. Each firm of attorneys has a pigeonhole at the magistrates' courts in which all documentation for the firm is placed. And after a certain number of days, when the clerk of court has granted default judgment in favor of the plaintiff or refused it, because they may refuse default judgment too for their own reasons. And the reasons may be that there is an error on the document is incomplete, or there is no cause of action, or the DAs have not expired, or there may be various reasons why the registrar or the clerk of court may feel that the plaintiff is not entitled to default judgment. And the reasons will most likely be written on the document or attached to the document, which is placed in the pigeonhole of the attorney's firm. The registrar or the clerk of court will be the person considering a request for default judgment. In respect of a liquid claim or a debt, where the claim is in respect of an illiquid claim, that case, that request or application for default judgment will be referred to a magistrate, and it may be heard in open court. Here is a checklist which you should use in practice too, to help you with a default judgment application. On my notes, it's at page 96. I don't know what page yours is on, because our notes are not the same. So when you apply for...
We're on page 99, advocate.
99, yes, thank you.
No, it's page 101.
Page 101, okay, right. This is the checklist. If you have a look at the checklist, it's rather long.
Yes.
And these are the things that will be considered. Was the summons properly issued? Was the summons date stamped by the clerk or the registrar? Was the summons signed by both the clerk of the court and the plaintiff and or his legal representative? Because if he doesn't have a signature on, the clerk will throw it out. Does the summons have a case number? Were all amendments to the summons initialed by the clerk of the court prior to service? Are the parties properly cited? Do the particulars of claim disclose a cause of action? Does the court have jurisdiction? Does the summons contain a prayer for interest? Is a particular rate of interest claimed, or is it interest merely claimed at the legal rate? Is a date given from which the defendant is alleged to be in mora? Were the correct DAs in ducia specified in the summons? Now, DAs in ducia is Latin for the court days. Court days, remember we said, are weekdays. Were they sufficient, or were they specified in the summons? Are the costs reflected on the face of the summons if it's undefended? One of the requirements that the summons must state that if the action is not defended, these are the costs that the plaintiff is entitled to. And they will look at that. If it's not on there, it does not pass the test for default judgment. Has the return of service by the sheriff been attached to the summons, and was the summons properly served on the defendant? And if it's a written agreement that is relied upon or a contract, is it attached to the summons? So those are the things that will be looked at. So you must be sure that, so these notes will come in good stead when you do start your articles, or when you practice. Even when you practice, you will need these notes to refer to them when you are faced with the relevant situation. Right, now I see your hand. Is there a question?
Yes, advocate, there's a question.
Advocate.
Yeah, I just have one question here. One of the questions that we need to address is this one that says, the parties properly cited in accordance with requirements of Rule 6. So yesterday, I was also carefully looking at Rule 6 and I think 5 as well. And one of the requirements, as you pointed out, is gender. Now, one of the issues we're dealing with currently, it's issues pertaining to people who identify themselves as gender non-conforming or gender non-conforming. So I just want to check how do we deal with that situation? Because if the requirement is that if we put this document, we must put gender, but others would say they are gender non-conforming. How do we deal with that situation? Thank you.
Thank you for your question. Certainly an interesting one. I have not come across a situation where the gender has been an issue. Most likely I will deal with it if and when it happens. Then I will deal with it. But for now, I think you need not worry about it.
Advocate.
Yes.
I think that whether it was a mistake or I didn't hear you very well, you said that the default judgment is granted by the clerk of the court. I was under the impression that it's being actually granted by the magistrate. You know, the files are taken to the magistrate, you know, to grant such judgments.
Okay. I said requests for default judgment in respect of claims for debt or liquid claims are considered by the clerk of court or the registrar of court.
Yes.
Illiquid claims are granted or considered by the magistrate. What did you miss about that?
Oh, no. I think that I heard you saying that, you know, and maybe I didn't actually hear you very well, but, you know, the impression that that came across was that the clerk of the court grant such judgments, and if so, that would be problematic. But I think that thanks for the correction.
Have I clarified it for you now, sir?
Yes, thank you very much, Advocate. It's clarified. Thank you.
Thank you.
Advocate,
Yes.
I just want to ask something. You said it's considered by the clerk or the registrar of the court. Does it mean that the registrar or the clerk, if it meets all the requirement, grants it?
Yes, sir.
Okay. Thank you.
Thank you. Now, Rule 11 of the Magistrates Court's rules provides for Rule 11 provides for judgment by consent. In other words, the defendant can consent to judgment being granted against him by the plaintiff. And it is very rare that you have such a consent to judgment taking place because the defendant merely needs to pay the debt. It amounts to that. I see a question there. Can you please also clarify rescission and variation of default judgments? Can we just hang on with that question, please? I'm still progressing and I will get to what it is that we need to get through. All right. Now, a judgment by consent is also contained on the summons. So when the sheriff serves the defendant with summons, the sheriff notifies the defendant that should you admit liability here, you may, on the back of the summons, admit consent to judgment. Then the job of the plaintiff becomes much easier. then the plaintiff can just apply for default judgment immediately. Does not have to wait for intention to defend, the days to lapse, does not have to wait for plea not to be filed because there's already a consent. And on that basis, will the plaintiff then be granted default judgment in its favor against the defendant? The defendant, when the defendant receives summons from the sheriff, may also admit liability. May also admit liability for the debt or for the claim, and may do so in writing. When served with the summons, similarly so to consenting to judgment. This may also be done at the stage of receiving a letter of demand already. I've seen some contracts too where the parties in the contract or agreement already agree that should either party be in default, that party consents to judgment and admits liability at that stage already of contract. Then there's not even a need for the plaintiff to issue summons. The plaintiff may apply for default judgment on the basis of that consent from the court. If the defendant, after receiving summons from the sheriff, wish to settle the debt in installment, that arrangement may be recorded in writing and filed with the court. In the event that the defendant defaults on that arrangement, the plaintiff and may also apply for default judgment, but with the provision that in that arrangement, the defendant consents to judgment being taken in the event of default of payment on the arrangement. Right, we are now dealing with defendant actions. The gentleman who asked about rescissions and variations of default judgment is way ahead of us. I will deal with it, sir. Please bear with me. Now, defendant actions. Now, when we spoke about default judgments, we said that it is because it is an undefended action. In other words, the defendant decided to remain supine, did not defend the action, did not file a plea. In this case, it's a totally different scenario. The defendant actually will now defend the action and will even file a plea and even a counterclaim. But we're going to deal with each of those now. After the defendant has been served with a summons by the sheriff, the defendant is given a period of 10 days within which to file a notice of intention to defend or an appearance to defend. Those two names are synonymous, and you must just know that they refer to the same thing. Very specifically about notice of intention to defend. Between 16 December and 15 January, that period of time is referred to as dies non. And that period is only significant for purposes of filing a notice of intention to defend, as well as a notice to oppose in an application. and nothing else. That must be clear. Nothing else will be affected by those days. It's only in respect of a notice of intention to defend or a notice to oppose in an application. And if you, and I'll make a practical example, if a defendant is served with a summons on the 14th of December, the 10 days within which after which the defendant must file a notice of intention to defend, should he or she so desire, will not include the 16th of December up to and including the 15th of January. So as I said, if the defendant is served on the 14th of December, the first day will be the 15th. You don't count the day on which the person receives the process. Day 1 will be on the 15th of December. Day 2 will be on the 16th of January, provided it's a court day. Day 3 will be on the 17th of January, provided it's a court day. Day 4 will be on the 18th of January, provided it's a court day. Day 5 will be on the 18th of January, provided it's a court day. I think you get the picture by now as to what I'm trying to explain about the dies non. Can we please mute our mics there? There's some sound in the background. Right, now, if a party, a defendant, let's say it's a defendant, if a defendant is being sued by a plaintiff and the defendant is concerned that the plaintiff, if the plaintiff proceeds with this action against the defendant, the plaintiff and the defendant wins the case for whatever reason, the plaintiff will not be able to afford to pay the legal costs of the defendant. The defendant may request via notice the plaintiff to file a security for costs. And Rule 62 of the rules provides specifically for that. So the plaintiff is then obliged to, within 10 days, file such security for costs. And the form of that security for costs may be decided by the registrar. Registrar may say they want a bank guarantee for a specific amount. The defendant, when the defendant asks for security for costs, must specify in the notice to the plaintiff what amount they will require as security for costs. And the registrar or the clerk of the court will then decide whether the amount requested is fair in the circumstances. Similarly so, the plaintiff may also require the defendant to provide security for costs in similar circumstances where the plaintiff is not satisfied that the defendant will be able to afford the legal costs of the plaintiff should the plaintiff be successful in the action. And where a party does not furnish security for costs to the satisfaction of the registrar, the other party may apply to court to strike out any pleadings which have been filed by that party, or ask the court to make any order that it deems fit including dismissing the claim or the defense of that party. So if a party who has been requested to furnish security in terms of Rule 62 fails to do so, that party is basically excluded from proceeding with its action or defense of the action.
Okay.
Yes.
What happened in a situation whereby the applicant happens to be successful in that case, and it appears as though the defendant is unable to pay the cost, and it is only the security that is available. What happens?
Don't you mean the plaintiff, sir?
Yes.
You said applicant.
Yes, that's what I mean, the plaintiff.
Yes. Remember, we are talking about actions here. The parties will be the plaintiff and the defendant.
Yes.
Not applicant and respondent yet.
Okay.
So can you repeat your question, please, referring to the proper parties?
What happened in a situation whereby the plaintiff got the defendant to secure security, and it happens that the plaintiff is successful with the action, and maybe the defendant is not able to pay the cost, and what is now available is the security. What is going to happen in that situation?
All right, thank you. That's a good question. The plaintiff will then, you must remember, the security that was filed by the defendant is tantamount to a liquid document. So the bank has to give a guarantee. It has to be an acceptable security for costs. So the bank will actually require, let's say it is 30,000 Rand, for the bank to give a guarantee that it will pay 30,000 Rand on behalf of the defendant. And here is the guarantee. So the bank will put a hold on that 30,000 Rands in terms of that security for costs. Upon succeeding, the plaintiff will then approach the bank with the bank guarantee and say, I was successful in this action against the defendant. Here is the court order or the judgment, and here is the security for costs, which was made in my favor. Then the bank will pay over that amount to the plaintiff.
What happened in cases of indigent litigants?
I beg your pardon? Is this in relation to security for costs? No.
Yes, yes.
I don't understand your question.
I'm saying with indigent litigants, will it still apply to them? Indigent litigants, in cases where somebody has to go to legal aid and get assisted to be maybe to sue somebody or whatever. So what happens, would that cost still apply to that person, or the security in question still apply to that person, because this person now is indigent?
That's a difficult question. But nevertheless, my view is that in the case of a claim for damages, I'm just trying to make it more practical now, because your question is very, very general, and I'm trying to think of a scenario where that would happen. It would not be fair of a party to request from an indigent person security for costs, and where that indigent person is required to file security for costs, the response by that party will be that I am an indigent person.
Yes.
I am not able to furnish security. Then the registrar will make a decision, or the clerk of court will have to make a decision whether that person will be required to pay, to furnish security for costs in those circumstances. Every case is decided on its own merits.
Yes. Because I mean, if the indigent litigant is denied
Access to justice.
Yes, yes.
Yes.
All right. Thank you, Advocate.
It's a pleasure, sir.
All right.
Advocate, under what circumstances would there be a need to invoke that? You said is Rule 61.
It's Rule 62, sir.
Rule 62. Thank you very much for the correction. Under what circumstances, and would that not impact on the constitutional right of the right to access to justice, which is enshrined in the Constitution?
Each case will be adjudicated on its own merits and facts. It is for that party at that particular point in time to inform the court of their circumstances. The court will not, in every case, insist on security for costs for each case that comes before it.
My question is, my first question would be, under what circumstances would there be a need to invoke that Rule 62?
Under what circumstances?
Yes.
Okay. As I said when I started this session on security for costs, when a litigant, be it a plaintiff or a defendant, is of the view that if that party is successful, the opposing party will not be in a position to pay the legal costs of that party, then that party may request the other party to file security for costs. Does that answer your question?
Yes, thank you, Advocate.
Thank you for your question.
Sorry, Advocate. Please, I don't know, is it not wise we continue with the discussion? And I like the questions, but let us cover some certain areas and then we can give room for questions, please.
Yeah.
I like the questions because we've not done anything. So we just one place, please. Sorry to interrupt.
Thank you. Right. All right, we're going to deal with declarations now. We said there are two types of summons. One is a simple summons, and the one is a combined summons. A simple summons is used in the cases of a debt or a liquidated amount or a liquid document. Now, when the defendant in a case receives a simple summons and decides to defend that summons, it is then incumbent upon the plaintiff to file a declaration. Now, a declaration is tantamount to further particulars of claim. Your simple summons is exactly what it says. It is simple. It does not contain elaborate paragraphs of particulars of the claim, because you are relying only on the liquid amount, which is based on a liquid document, which may be an invoice or a check or something to that effect. And only when the action becomes defended does the plaintiff become obliged to file what is called a declaration. And that declaration, in terms of Rule 21B, capital B, must then file that declaration which must be equivalent to particulars of claim. Should the plaintiff not file that declaration within the time stated, the defendant must place the plaintiff under bar by serving him with a notice of bar, requiring him to file a declaration within 5 days. And if the plaintiff fails to file that declaration within 5 days, is automatically barred from delivering that declaration. And the defendant may then apply to have the plaintiff's claim dismissed with costs. That was Rule 15. You are to read up on the rule itself to see what is contained therein. But that in a nutshell was Rule 15 declaration. Rule 19, we are coming to exceptions and applications to strike out. When a plaintiff's summons and particulars of claim are vague and embarrassing, in other words, they contain facts which are not clear, are not easily discernible or understandable by the defendant. The defendant may raise what is called an exception in terms of Rule 19. So it'll be by way of a notice in which the defendant says to the plaintiff, your summons and particulars of claim are excipiable in the following respects. Because they are vague and embarrassing, they say the following at paragraph so and so. I am unable to understand what you mean. It is vague and I'm embarrassed to respond to it. Referring to specific paragraphs or allegations in the summons and particulars of claim, and then asking the plaintiff then in the same notice to remove those causes of complaint within a period of 10 days. And if the plaintiff does not remove that cause of complaint within 10 days, the defendant will deliver an exception in which it will ask for those portions to be struck out or that the defense of the plaintiff be struck out. That is the one instance of an exception. If the particulars of claim or and summons of the plaintiff do not disclose a cause of action, in other words, it is not discernible from the papers of the plaintiff by the defendant as to what the cause of action is, the defendant may deliver an exception to have the plaintiff's claim dismissed. And the difference here is that the defendant does not have to send a notice to the plaintiff to remove the cause of complaint. The defendant may straight away apply for the plaintiff's claim to be dismissed with costs. Right. We are now going to deal with the actual plea. Now, when the plaintiff's claim is contained in the summons and particulars of claim. Now we are referring to combined summons here. When the defendant receives the summons and particulars of claim from the sheriff, the defendant decides, I actually have a defense to this claim. I do not owe this money, or I have paid this money. The rules require that the defendant's defense to the claim of the plaintiff must be a bona fide defense and not a fake or a mala fide defense. It must be a real defense, such as the examples that I've made. Either the defendant does not owe the plaintiff money, and will have to prove that, of course, will have to provide proof, or that the defendant has paid the money and will have to provide proof of that, and that will be the end of the story. And the defendant has a specific period of time within which to file the plea. And that is normally 20 days, court days after service of the notice of intention to defend, or the declaration that has been, after the declaration has been provided by the plaintiff. Like I said earlier, if the defendant does not file a plea within the 20 days or the time specified in the summons, the plaintiff may place the defendant under bar. In other words, serve them with the notice of bar and tell them, if you do not file your plea within 5 days of this notice, receiving this notice, you will be ipso facto barred from doing so. And then you will not have a plea at all. And then the plaintiff may apply for default judgment. The same basic rules apply in that the plea must have a heading specifying the court out of which the pleadings are served, the case number, the names of the parties, and the heading must state it's a plea. In a plea, when a defendant files a plea, the plea must either admit or deny the allegations in the plaintiff's claim. The plaintiff cannot, and where the plaintiff does deny any allegation in the summons, the defendant must put a version to the court. Cannot merely say, the defendant denies the entire contents of this paragraph and puts the plaintiff to proof thereof. In addition to admitting or denying, the defendant may confess and avoid the allegations that are made in the summons. I have seen defendants responding to claims or allegations in summons by saying, I have noted the contents. The defendant notes the contents of these paragraphs. Is noted an admission or a denial? If I was for the plaintiff in that case, I will most certainly argue that the defendant has admitted this allegation. He has not denied it specifically, but it must be taken to have been admitted. He has admitted the allegation therein. If you merely say that you do not have any knowledge of the allegation in a specific paragraph in the summons or the particulars of claim, that also does not amount to a denial. You must specifically say that you deny a specific allegation and not merely say you have no knowledge of it. If you say you have no knowledge of the facts in this paragraph, you must say, and for this reason, the contents thereof are denied, and the plaintiff is put to proof thereof. You cannot put a version unless you do have a version, but you cannot put a version to something you have no knowledge to. And sometimes the defendant may be in a position to clarify or elaborate as to why he or she has no knowledge of the contents of that paragraph. Please check that your mics are muted. I hear sounds in the background. Now, a defendant may also raise what is called a technical defense to a claim. And this is called a special plea. A special plea is a special defense that is raised by a defendant, which may either be a plea of lack of jurisdiction by the court, lack of locus standi by one of the parties to the claim. It may be prescription. It may be res judicata. It may be that the contract in respect of which this claim has been instituted is based on a clause that provides for arbitration before coming to this court. And that has not been explored by the plaintiff, and therefore the plaintiff's claim cannot proceed because of that special plea of arbitration. Now, after a defendant has served the plea on the plaintiff may apply for summary judgment, but may only do so in certain circumstances. And those circumstances are as follows. Where there is a liquid document that the plaintiff's claim is based on, that the amount is for a liquidated amount of money, the claim is for delivery of specified movable property, or for ejectment of the defendant from premises. In those four instances, the plaintiff may apply for summary judgment against the defendant, and not necessarily because the plea does not disclose a bona fide defense. That will be part of the plaintiff's case in applying for summary judgment. So only in those instances may you apply for summary judgment as a plaintiff or on behalf of the plaintiff. The application then for summary judgment, which is an expedient remedy, because now instead of going the whole route of filing all the pleadings and notices and going to court, you may at that stage already ask the court to intervene and to give you summary judgment without the case going the full 9 yards, as they would say. So when you receive the plea and you see that it doesn't disclose a cause of action, you issue an application for summary judgment on notice, of course, and your summary judgment notice will be accompanied by an affidavit of the plaintiff in which is set out the plaintiff's case for the relief sought. And the facts will be stated there as follows. On this date, the plaintiff instituted action against the defendant for a claim for blah, blah, blah. The claim is for a liquidated amount of money, or it's for a liquid document, or it's for delivery of a specified movable property, or it's for ejectment. And then you go on to say that in terms of Rule 14, the plaintiff is entitled to apply for summary judgment in the circumstances. Then you continue in your affidavit by saying that plaintiff is entitled to apply for summary judgment for the following reasons. The defendant filed a notice of intention to defend on this date. It can be found in the index under this page. The defendant also filed a plea on this date in which the defendant set out his defense to be as follows. I respectfully submit that this does not amount to a bona fide defense, and for that reason, I request this honorable court to grant summary judgment in my favor against the defendant. Then that will accompany your notice of application for summary judgment. It will be served if the defendant is represented by a firm of attorneys. It will, the attorneys for the plaintiff will then serve it on the attorneys for the defendant. But it must be done within 15 days of receiving that plea. You cannot wait for 2 months or 3 months for that matter. You must do it within 15 days of receiving the defendant's plea. All right, there's a slight difference with the National Credit Act claims. In terms of section 169(1), you just need to familiarize yourself with that, as well as the cost of the credit that may not exceed the maximum permitted. Also with claims for debt, there's case law that says that a creditor may not charge debt that interest on a debt that exceeds the debt. In other words, it's also referred to as the in duplum rule. So you may not exceed the actual debt. So if a creditor comes to court and sues you for 20,000 Rand, the interest thereon may not exceed 20,000 Rand. So Rule 14 also tells you what costs you're entitled to when you apply for summary judgment. All right. In a nutshell, that was summary judgment then. Any questions on summary judgment? Can I ask that we keep our questions relevant to the topic that I've dealt with, and not to jump the gun to something which I may be dealing with later on? All right, so we all seem happy with summary judgment so far. Read.
Summary judgment does it expire?
I beg your pardon?
A summary judgment, does it expire? Does it have a time limit after application?
15 days.
15 days.
You must bring it within 15 days of the defendant having filed its plea. If you don't file it within 15 days, that boat has sailed and you've missed it. You've missed the opportunity.
And let's say it was granted, is the expiring date on that?
If it was granted?
Yeah.
I don't understand what you mean by the expiry date of that. If it's granted, you must act upon it. You must then execute on that judgment.
Oh, okay.
Yeah, the same applies with the default judgment. If you've got default judgment, you may execute thereon by issuing a warrant of execution against the property of the defendant. That is the purpose of a judgment. That is how you enforce a judgment, is you send the sheriff with the judgment attached to the warrant of execution or a writ. And you tell the sheriff, go there to the defendant's property, to the defendant's address, and demand payment of this money in terms of this judgment, either default judgment or summary judgment. And if they do not pay it, then you attach property to the value of the amount in the judgment.
Okay, thank you.
Is summary judgment appealable, Advocate?
Is summary judgment appealable?
Yes.
What do you think?
I would say it's not appealable.
Okay, why not?
it could be clear on the facts that either the defendant has no defense.
Okay. Does anyone else have an opinion?
I think
I would say it's appealable.
Okay, why would you say that?
Would we not have to request maybe reasons from the magistrate? Because there could be an error in proceedings, for example.
You are talking about review now. If you are talking about errors,
Oh, I see.
then you are
Okay.
treading on review now.
It is appealable because a judgment has been made with respect to the fact that possibly the defense holds no water.
Okay. Does anyone else have a view?
I would say it is appealable if the order made is unreasonable and maybe unjustifiable.
Okay. Anyone else?
I would say that it will differ on the merits. It can be appealable if, I will make an example, if maybe the defendant at the time was not aware of the summons that were issued. Probably maybe if they provide reasons that they were not aware and those reasons are valid. An example can be that the person was out of the country, because sometimes what happens that with the sheriff, they can serve you with the summons. If they don't find you, they just put them in your doorstep, where they will assume that you will be able to see them, and based on that assumption, you can approach the court with proof, of course, concrete proof to show that you were not aware of the summons. And
then you've got grounds for rescission then of that order instead of appeal. The question was, is a summary judgment appealable?
It is a judgment. Yes. It's appealable.
Yes.
Every judgment is appealable.
Yes. I think it is.
Sorry,
a constitutional right.
Can we have one at a time, please?
I think it might, depending on the merits or the circumstances of the particular case, it might be appealable or not appealable, depending on whether a different court may arrive at a different decision. Thank you.
Okay. Next.
Say, I don't think it's appealable.
Final judgment of the court. It's the final judgment of the court, and it's therefore not appealable.
Can I say something?
Yes, you may.
No? I would say it's appealable because, first of all, it's a clerk of a court makes the decision. Okay, but the facts are that he had the opportunity to dispute it.
Okay. A summary judgment is not appealable. It's a final judgment of a court.
Because it's an interlocutory process.
It's a final judgment of a court. So it's not appealable. You may rescind a summary judgment. See that that toddler agrees with me. Mr. Lyon, your son agrees with me there in the background. Can you mute your mic, please?
Oh, I apologize, sir.
Thank you. So a summary judgment is a final judgment and is not appealable. You may rescind that judgment if good grounds exist. You must remember, a summary judgment is a judgment granted by the court because the plaintiff said the defendant does not have a bona fide a bona fide defense. And the court has made a finding agreeing with the plaintiff that the defendant's defense does not amount to a bona fide defense. Okay, but some good responses there. That's what we'd like to hear. Can I suggest that we take a short break of 15 minutes? And then we can come back at 7:05, please. Thank you.
Thank you.
Thank you.
Thank you.
Thank you, Advocate.
Right, we are back. I noticed from your program that we are only together for 5 days. Tomorrow is our last day together. And that you have self-study for days 6, 7, 6 and 7. If time allows, because I noticed that we're moving at quite I don't want to call it a rapid pace, a steady pace. We are almost caught up with the programs despite having lost a few hours on Tuesday. And that's because things have been going smoothly and we haven't been asking irrelevant questions. We're quite on par with the program so far. Should I have a bit of spare time left tomorrow? Should we still have time left and I have covered some of the topics sufficiently, I may, take note, may touch on some of the self-study topics. I already have. I've touched on applications, I've touched on execution, I've dealt with judgment by default. I may touch on section 65 for you, appeals and reviews briefly, all right? Maintenance courts and other forums, I may touch on that too. Time permitting, of course, all right? That's what I'm prepared to do for you, should we finish on time. You will notice that I skip some of the topics in the notes. That is because I feel that I'm touching on what I deem important, not more important than what is contained in there, but what I think I need to explain to you. What I have not touched on, you must please, in your own time, read through it. But also make notes of points that I have not touched on. Not to touch on in future, but have not touched on yet. All right? Now, Rule 18, capital A of the Magistrates Court Rules provides for a party to apply to court for an interim payment. But this is only in respect of actions for damages for personal injuries or the death of a person. An example I'll make now is a family loses a father in a car accident. The children and wife of that man institute an action against the road accident fund for damages for loss of support. That family is also entitled to submit a claim for funeral costs. And because they do not have money to bury that man, they may apply to court for an interim payment for those funeral costs. But my experience is with the road accident fund, if your claim includes a funeral claim, a claim for funeral expenses, they normally settle that claim quite speedily because they know and understand the predicament that the family is in when it comes to burying their loved ones after an accident which caused the death of that person. Another example is in a medical negligence case. And remember, we are talking about personal injuries now, right? Where a person suffered severe injuries and has been taken to a hospital which or rather the person suffered injuries whilst they were in hospital. They went to hospital to remove a cyst on the arm and ended up having their leg amputated by mistake. It happens, believe me, it happens. In order for that person to function, they need to be provided with a prosthetic leg, which costs 300,000 rands. The claim is still pending. The person needs that prosthetic leg to be able to perform their work and provide for their family. That person may apply to the court for an interim payment of that 300,000 rand to get that prosthetic leg, because it is a personal injury claim. I hope that makes sense. But when that person applies for that interim payment to court, they must, in their application, accompany that notice of motion with an affidavit in terms of which they will set out the entire cause, what the application is for, why are they bringing this application, and if the application is necessary. And only when the court has considered those circumstances, and if there are genuine circumstances put in there by the plaintiff, the defendant normally does not oppose those applications, and the courts normally grant those orders. But also important, when in litigation of this nature, before embarking on a litigation itself, it is always advisable to write a letter to your opponents in which you tell them, my client is being prejudiced by the delay of this claim, which will only see the courtroom doors or steps in about a year's time because we are waiting for other reports. In the meantime, my client is in need of a prosthetic leg, which costs 300,000 rand. There is the quotation. Would you please be so kind as to consider this request to do an interim payment of this amount of money? Because my client needs it to start his job on the 1st of April. Otherwise, he will lose it. Here is a letter from his employer saying that if he doesn't have a leg to stand on, excuse the pun, he will lose his job. In those circumstances, the defendant is normally reasonable, and they come and they say, sir, by all means, here is the 300,000 rand for the leg, or we will pay it straight to the provider and he can stand again and he can work. Yes, ma'am.
I just needed clarity on the point. So at which point during the proceedings can the plaintiff make this request? Because is it when now the claim has been proven that the defendant is guilty, or can this be requested at any point in time? Because I'm just thinking that if perhaps the request is granted and then it later turns out that the defendant is not guilty, then they might have to pay the money back, unless there's something that I'm missing.
Okay, no, it has not got to do with guilty. Remember, guilty is in respect of criminal cases. We are dealing with a civil case here. The correct terminology is liability. Yes, liability.
Yes, liable. Yeah, sorry.
It's liability, yes. Where liability is not in issue, obviously is an important factor, because then the first point that the defendant will raise is that, but liability is still an issue here. So you are not entitled to it. All right. It's where the court will have to be satisfied that liability by the defendant has been admitted. Right? That's a factor as well. It's not a question of any time. The defendant must have admitted liability already.
Okay, thank you.
In cases of this nature, the courts prefer to deal with the issue of liability and then with the issue of quantum at a later stage. So where the court has either found that there is already liability against the defendant, or the defendant has conceded liability, then the court will consider the issue of an interim payment. But thank you for your question. It was a valid question.
Thank you.
Right, now let's move on to claims in reconvention. Now, a plaintiff may sue a defendant for, let's say, 180,000 Rand for fuel sold and delivered, because the defendant's trucks have an account. The defendant has an account with the plaintiff that the plaintiff will sell and deliver to the defendant fuel for the use of its trucks. The defendant pays the plaintiff at the end of each month for the fuel used during the month. Should the defendant fail to pay for the fuel, the plaintiff within 30 days, that's part of the contract. The fuel must be paid within 30 days. If not, the defendant is in default of the contract. The plaintiff then sues the defendant for 180,000 Rand, which is the value of the fuel sold and delivered. The defendant then decides to defend that action on the basis that one of the defendant's trucks became damaged because the plaintiff's fuel attendant put in diesel instead of petrol, or rather the other way around, petrol into the truck instead of diesel. And now the defendant has suffered damages of 100,000 Rand as a result of that. The defendant will then institute, when the defendant files a plea to the plaintiff's claim, the defendant will institute or introduce a counterclaim. And a counterclaim is also referred to as a claim in reconvention. So your summons and particulars of claim are referred to as a claim in convention, whereas your counterclaim is referred to as a claim in reconvention. So now you've got two actions. You can call it that. You can say you've got two actions in one. The first action is that of the plaintiff against the defendant, and now the defendant has introduced an action against the plaintiff for the damage to the truck. There, the counterclaim will be drafted in exactly the same way as the particulars of claim in the summons, providing sufficient particularity with regards to the parties obviously will remain the same, and there's no need to rename them. The plaintiff in convention will now be the defendant in reconvention. That just creates confusion. Just stick to the parties as they are. The defendant now introduces a counterclaim against the plaintiff. The defendant had trucks delivered. The trucks of the defendant had inserted fuel, namely diesel, at the plaintiff's premises. On this particular day, you give the date, one of the plaintiff's employees, whose name is unknown to the defendant, filled up the defendant's truck with petrol instead of diesel. As a result of this, the defendant's truck became damaged. The amount of the damages is 100,000 rands, and the defendant holds the plaintiff vicariously liable for the actions of the employee of the plaintiff. Wherefore, the defendant claims payment or judgment against the plaintiff for payment of 100,000 rands, interest thereon, costs of suit. That is what a counterclaim will sound like. And then under normal circumstances, yes, you may tell people that it's abnormal not to be represented by an attorney. In normal circumstances, the attorney will be the one drafting that plea, or rather the counterclaim, and serving it on the attorneys for the plaintiff. The plaintiff, on the other hand, will have the opportunity to file a plea to that counterclaim. Remember, the counterclaim of the defendant is couched within a plea. So the plea will say, I admit, I deny, confess, I avoid, and avoid. All of that in the plea. And then after the plea, the defendant will introduce his or her counterclaim as a part of the pleading, but it will be headed counterclaim, and it will have its own allegations therein in respect of the counterclaim. When the plaintiff then receives the plea and the counterclaim of the defendants, the plaintiff has an option either to replicate to the plea if there is anything that the plaintiff feels he or she wants to put into dispute or respond to. But it's not in every case that the plaintiff wishes or needs to replicate. At the same time, the plaintiff will also, in the same document, respond or plead now, file a plea to the counterclaim of the defendant. And just as in the particulars of claim, the plaintiff may now also raise a special plea in the plea to the counterclaim, either on jurisdiction, locus standi, arbitration, lis pendens, and the ones that we've mentioned. So these are examples of how parties may plead. And after the plaintiff has filed a plea to the counterclaim of the defendant may file a replication to that plea. But that is the end of pleadings. No more pleadings may be filed after that. In other words, because for the simple reason that parties will ad infinitum, without any end in sight, want to file papers. And the same applies to applications. In applications, only 3 sets of affidavits are allowed. The first affidavit is that of the founding affidavit, which will accompany the notice of motion. Then that's by the applicant. The respondent will then file an answering affidavit, to which the applicant will file a replying affidavit. There are only 3 sets of affidavits allowed, no more. Only in exceptional circumstances will the court give a party leave, but on application and by way of court order will the court grant a party leave to file any further affidavits, only where new facts have come to light, but not in just any circumstances. Now, coming to the close of pleadings. So after that replication and the plea in reconvention have been filed, the parties need to now consider to close this thing. In other words, when are pleadings considered closed? And Rule 21, Sub-Rule A deals with the close of pleadings. And it reads specifically as follows. pleadings shall be considered closed if either party has joined issue without alleging new matter and without adding any further pleading. B, the last day allowed for filing a replication or subsequent pleading has elapsed and it has not been filed. C, the parties agree in writing that the pleadings are closed and such agreement is filed with the registrar of or clerk of the court. Or D, the parties are unable to agree to the close of pleadings and the court, upon the application of a party, declares them closed. So there are very specific instances when pleadings will be closed. And it's only under those circumstances, these four which I've mentioned, will pleadings be considered closed. What does it mean now? What does it mean that pleadings are closed? It means that the matter is, the case, the action is almost ready for trial. And when it's almost ready for trial, the parties can now prepare for trial. It doesn't mean that a date will be allocated immediately for trial. It can only be applied for at this stage. But then the parties still need to file pre-trial notices. We are now going to deal with some of those notices.
Sir, may I please ask a question with regards to the affidavits?
You may.
When can we supplement our affidavits? And in those supplementing the affidavits, are we allowed to bring new facts?
You may only supplement, you may only file a supplementary affidavit if there are new facts which were not present or known to the parties when the first three affidavits were filed. And you may file an affidavit, a supplementary affidavit, if you want to correct a mistake that was made in one of the previous affidavits. Those are the only instances when you may file additional affidavits, but you must apply to court on application, and the court will consider your application, and the opposing party has an opportunity to oppose that application should they feel that you are not entitled to file a further affidavit, or that the facts that you want to disclose have already been disclosed or are not necessary or relevant for purposes of the application.
Noted, thank you.
Thank you. Is there another question?
Yes, yes.
What is your question, sir?
My question is with regard to the the plea. You've got 20 days to reply to serve the plea, and I just wanted to ask and understand if after serving the plea to the plaintiff, then is there a specific period for you to file the same plea with the court?
All right. What normally happens is, or what should happen, is that when you have served any pleading or any notice on the opposition, the attorneys or the other party, you must file the original of that document in court.
Yes.
Preferably on the same day or the next court day. Have I answered you?
Okay, so say for instance, in the event where you find that maybe you take a week, is there a penalty or something with regard to that?
No, only if something has happened in the case in a week's time and they discover that it has not been filed. Then
Oh,
Yes. Then then only will they know that it has not been filed.
oh, okay. All right. No, I understand.
But the procedure is, after you've served it on your opponent, you go and file it at court. And proof and service is proved by the opposition party's attorney's firm putting their stamp on it and signing it, writing the person's name who receives the document. They put a date and they put the time of receiving the document. They will put that information on all the copies, including the original. That will serve as proof that you have served them with the document. And thereafter, immediately, or the next day, you are to go and file that document at court, the original. File the original court. The court will put a stamp on the original. The court will put a copy on your copy as well. We'll put a stamp on your copy as well. So you have in your file now a copy of that original pleading or notice with the court stamp, with the date stamp as to when the court received it, as well as the date stamp of when the opposing attorneys received it. Practically, that's how it must happen.
Okay, I'm answered. Thank you.
Thank you. And the same will apply in an application with affidavits. When a party files an affidavit, they must make use of a notice of filing. Right? The notice of filing will have the heading of the case, the court, the parties, the case number, and it'll be headed notice of filing. And then it will say, take notice that the applicant hereby files his replying affidavit. And then the attorneys will sign. There will be written below that to the clerk of the court or the registrar of the regional court and to the respondent's attorneys. You then attach the replying affidavit to that notice of filing, which must be signed. Then make sufficient copies and go and serve that affidavit on the attorneys for the respondent. They will then put a stamp on the notice of filing where their name appears. They will sign it, write the name of the person receiving the document, and put the time and date thereon. The candidate attorney or the messenger which served the document on the respondents, the affidavit, will go to court with the original and put a stamp thereon. The clerk or the registrar of the court will put a stamp on the notice of filing with the date to show it was filed at court. And you will have a copy on your notice of filing to prove that you filed the affidavit at court as well. That is how it happens practically. All right, now let's move on. Rule 21, capital A, provides that if any party fails to deliver a pleading, that party is automatically barred. So we spoke of a notice of bar. Where a party fails to file a pleading, you may put them under bar by serving them with a notice, giving them 5 days within which to comply. Should they not comply with it, they are automatically barred from filing that plea. The same happens to a declaration in a simple summons. When a defendant has received a simple summons and filed a notice of intention to defend, the plaintiff must file a declaration within 20 days. And should the plaintiff fail to file that declaration, the defendant will serve a notice of bar on the plaintiff to say, you were supposed to file a declaration, by the way, within 20 days of receiving my appearance to defend. You've not filed it. I'm hereby giving you 5 days within to file that declaration, failing which you will be barred. And if they don't file the declaration within that time, they will be barred. Then, as I said earlier on, you may either apply for the defense to be struck out, and you may ask for the claim to be dismissed with costs. So you first have to bar a party. The same happens with the replication. If they have not filed a replication to a plea, you may also serve them with the notice of bar. And if they do not file a replication, they are barred, and you may then move on without them having replicated. Your version in your plea will then be accepted. You can argue that in court. So there's no need to file a notice a notice of bar in the case of a replication. It's a choice which the parties have. If they want to file a replication, they have a choice to file it. If they don't, the DAs will overtake them. And in terms of the rules with pleadings, Rule 7, 10 days is the time period in respect of all pleadings. So after the plea, the replication, you have 10 days. And if 10 days have lapsed, that boat has sailed and you've missed it. You can't file a replication. Right, now amendment of pleadings. Rule 55, capital A. Pleadings, now referring to a summons, a plea, a replication, or a counterclaim. Those may only be amended in terms of the rules. And you amend a pleading by giving the other side notice of your intention to amend. You'll have the heading, court date and the parties, the case number, and you will say in that notice, it will be headed notice of intention to amend. Take notice that the plaintiff intends to amend his particulars of claim in the following respect. 1. By deleting paragraph 5 and by substituting it with the following. On the 8th of November, 2022, the plaintiff was driving his motor vehicle along Oxford Street, full stop. Then at the end thereof, if there's any more amendments that the plaintiff wants to effect, they will all be set out meticulously in that notice of intention to amend. And at the end thereof, the plaintiff will say to the defendant, take notice that if you do not object to this proposed amendment within 10 days of receipt of this notice, the amendment will be so effected. And the plaintiff must be careful, or any party who wishes to amend. Even the defendant may amend their plea or their counterclaim when they realize that something is wrong in there, or something has changed that warrants an amendment. For instance, the amount of money may have changed because they have now obtained a quote, or they have now obtained a report to support the amount. Then they may make an amendment, but along those same lines. And if the 10 days have expired and the party has not objected in writing to it, then that party may effect the amendment by putting in the amended portions in the existing pleading and filing it with the opposite party. If a party objects to an amendment, the party that wishes to amend may bring an application to court. And remember, if you are objecting to an amendment, you must state the reasons why. And if those reasons are not valid, the party that wishes to amend may bring an application to court to say to the court, I tried to amend this pleading. My opponent has objected thereto. I submit that the objection holds no merit and is without justification. It is a delaying tactic. It is prejudicial to my client. Therefore, I ask that the amendment be effected, and the court must order that the opposing party to pay costs on an attorney and client scale for the unnecessary delay of this case. The court will normally grant that if it is satisfied with your facts in support of that application for an amendment. Now, amendments in terms of the rules may be effected at any time, provided that the magistrate has not pronounced or issued a judgment, delivered a judgment on the case. So when a trial starts today, and let's say it finishes tomorrow, and because of the evidence that has been led, you realize now that your client's case was not sufficiently pleaded to align itself with your evidence. And it's not necessarily the opposite of what was pleaded, of what was that they are in opposition to each other. No, not that at all. Because you cannot change a plea from an admission to a denial. You can change it otherwise from a denial to an admission, but not from an admission to a denial. And there you will then be required to after the evidence has been led and the magistrate has not handed down the judgment yet. Is everything okay there? Someone's showing us a picture. Okay. The magistrate has not handed down judgment. It is expected that judgment may be handed down in a month's time, giving any party an opportunity to effect any amendment in accordance with the evidence. You may do that, provided, of course, that your opponent doesn't object and doesn't raise a valid objection. Then you bring the amendment along the same lines. Notice of intention to amend. Plaintiff intends to amend its plea, its particulars of claim in the following respects, blah, blah, blah. And you set it out. And then you say, give them the 10 days within which to object. And if the court hasn't given a judgment in those 10 days, you perfect your amendment. Then you can still argue that, or rather, when you appeal and it goes against, if the decision goes against you, you can still argue that it was pleaded that way, and as a result, the court was wrong, and you can use it as a ground for appeal. Okay, right, now we said that when pleadings are closed, all right, I will allow time for questions now, if any, on what I've just spoken about.
Advocate?
Yes, sir.
Just a quick question. I just wanted to know, in terms of amendment, is just wanted clarity. It's a clarity question. Is it Rule 28 applicable in the Med or High Court?
Rule 28 is in respect of the High Court, sir, for amendments.
All right, thank you so much.
In the Magistrates Court, amendments are in Rule 55, capital A.
Thank you.
Right. But you must also read Rule 55, capital A, with Section 111 of the Act, because there too they deal with amendments. The rules must always be read in conjunction with the Act. The rules, the Act tells you what you can do. The rules tell you how you must do it. The two must be read together. Okay, we are now, let me have a look here quickly at program to see where we are. Yo, we are ahead. We are way ahead, but anyway, it's not a bad thing, it's a good thing. Okay. Any questions? There was a question there. All right, just to go back on, I see on the chat there were questions earlier on. Anele Bumisa, can you please also clarify rescission and variation of default judgments? I see Sipo tried to give an explanation there. Anele, are you covered? Would you still like me to deal with that?
Oh, I'm covered. Thank you.
Okay, thank you. Thank you, Sipo, for that. Nhlakalipo, will you please at a later stage give an example of POC that do not disclose a cause of action? Sure, I can do that. In the particulars of claim, the plaintiff alleges that there was an agreement between the plaintiff and the defendant. The agreement was verbal. The defendant did not comply with the agreement and therefore is liable to the plaintiff. What is missing there? Does that disclose a cause of action? Nhlakanipho, I'm asking you because it's your question. Anyone feel free to assist?
No, it doesn't.
It doesn't.
The amount that they're claiming for, or that they agreed upon, basically is not disclosed.
Okay, is there anything else that's perhaps missing there? Is that the only thing that's missing?
Cause of action, breach of contracts. Can you say that by?
Yes, that is correct. You may say there's no allegation of the breach of contract. What about the terms and conditions of the agreement? What were the terms? They are not set out in the particulars. So how is the defendant to know that what there were terms and what those terms were, and what the obligations were? More particularly, what were the obligations of the defendant? How is the defendant to respond to that, not knowing what those conditions are? What about default? There's no allegation of default. The only allegation made by the plaintiff is that the defendant has not met its obligations in terms of the agreement. So, Nhlakanipho, do you see there's an example of a POC that do not disclose the cause of action? Are you satisfied? Okay, your silence will be taken as consent. Okay. Will this notice also be required when serving summons? Nhlakanipho, again, which notice are you referring to? Will this notice also be required when serving summons? Okay, we'll come back to that one. Dion Anthony September says that is Rule 21B, barring for failure to deliver pleadings, and not 21A as per the guide. Let's have a look. See, the guide says barring. Okay, let's see. Yes, that is correct. The notes on the notes under 8.12. I hope I've got it right. They say Rule 21A failure. Excuse me, let me just see to this noise here. Sorry about that. Yes, it is Rule 21B that refers to barring and not Rule 21A. Rule 21 capital A is in respect of close of pleadings. So thank you for that correction there, Dion. Just make sure that you, in your notes, make that correction as well, or yeah, make the note there on your notes. Filing notice. Nhlanganipo says filing notice. Will this notice also be required when serving summons? No, sir. You don't need a filing notice when you are serving a summons. I'll tell you when you need a filing notice. You need a filing notice when you are filing a document in an action, right? Such as a report, or an affidavit only. In applications, you don't need a notice of filing when you are filing the founding affidavit, right? Because you are initiating proceedings with it. And it's accompanied, the founding affidavit is accompanied by the notice of motion in any event. And your notice of motion will say so, that your notice of motion will say that the founding affidavit of the applicant will be used in support of this application and is annexed here too. So you have your notice of motion and your filing affidavit attached there too. Your affidavits after your notice of motion will all have to be filed by way of a notice of filing. Your answering affidavit must be filed by way of a notice of filing. Your replying affidavit must be filed by way of a notice of filing. Any supplementary affidavits must be filed by way of a notice of filing. And that is because in pleadings, on the pleading itself, you allow space for the filing, for the details of the party that is filing the pleading. You are allowed to do that. Whereas, at the end thereof, whereas in an application, affidavits may not be written on or stamped on because you'll be defacing the affidavit. Remember, an affidavit is a statement under oath, and it is almost called a sacred document because of the nature of thereof. It contains a statement by a person in their first person. So you are defacing that document. That is why you need to file it by way of a notice of filing, not on its own. Okay, so that covers the filing notice. Putitao says, can the court close the pleadings even if no party has applied for declaration to be closed? No, sir, the court cannot. Remember, the court only reacts in a case when the parties move. And the plaintiff in an action and the applicant in an application is always considered to be dominus litis. Loosely translated, it is the dominant litigant, or I call it sometimes the driver of the bus. And if the driver does not move the bus ain't going nowhere. So you, as the plaintiff, have a duty to move your case. The court will sit there. The court doesn't care. Your case in the court is just a file that's there in a cabinet. And if you don't do anything, it's not going to walk to the magistrate or the clerk of the court. Those people have lots of work to do, and they're not going to wait for your file to walk to them. So if you do not come to the court and say the pleadings are closed, I want to now apply for a trial date, it ain't going to happen, okay? It's not going to happen. So yes, the parties must move their matters. But having said that, the plaintiff and the applicant being dominus litis in their cases does not exclude or preclude the defendant and the respondent in their cases from moving when they see the plaintiff and the applicant are not doing anything. You also, as a defendant or a respondent, want finality on your case, and therefore you must move. If you see the plaintiff is not doing anything, set it down. apply for a trial date, apply for a date in the opposed role. So you've got a duty as well to move your case forward. Right. We have about 30 minutes left. Let's see what we can cover in this time.
Advocate.
Yes, sir.
What one should do in the event where the magistrate or judge delays to deliver his or judgment?
Okay, we are now dealing with magistrates only, okay, because this is magistrates court's practice. If a magistrate delays with delivering a judgment, one of the parties may write a letter to the chief magistrate of that court and ask them and tell the chief magistrate that this case was heard on this date. These are the names of the parties. This is the case number before magistrate so and so. It is now 9 months later and we still do not have a judgment. We kindly request you to impose on the honorable magistrate to deliver the judgment. Magistrates, like judges, have, in terms of the standard rules of practice and the norms and standards, 6 months within which, a maximum period of 6 months within which to deliver their judgments. And if they don't, you have the right to then approach the head of that court, who's the chief magistrate, to ask them where the judgment is and to implore them to deliver that judgment. And because you asked, yes, the same situation happens in the High Court, you may write to the judge president. Are you covered?
Yes, thank you, Advocate.
Thank you. Now the pleadings have closed and you are anxious to go to court. Remember, we are still dealing with an action now, trial. You will draft a notice of an application for a trial date. It's a simple one-pager, if not 2 pages, in which you will address it to the registrar or the clerk of the court, as well as to your opponent's attorneys. And fortunately, you may be dealing with attorneys on the other side, because it's very difficult dealing with a person representing themselves. They will come up with all sorts of excuses. They are a lay person, they don't understand the rules, and they don't know court procedures. Why do you represent yourself if you're not familiar with the rules? So be thankful when you have a firm of attorneys on the other side. You will not have those excuses of not being ready and not understanding the rules of court. So you prepare your notice of application for trial date, telling your opponent, I am now applying for a trial date because the pleadings have closed. Take notice that the plaintiff hereby applies for a date of trial in this action. Full stop. That's all. You serve it on them and you go and file it with the registrar. And when you file it with the registrar or the clerk of court, you tell them, with this notice, I'm applying for a trial date. The pleadings have closed. The clerk of court or the registrar of the regional court will then allocate a trial date. They will go through their diary and give you a date not less than 6 weeks from the date of trial. You are then, when you receive that allocation of trial date notice from the registrar, you will then draft what is called a notice of set down, telling the other party that this case is set down for trial on this date. but you may not serve that notice on them less than 20 days before the trial day itself. And they can't say to you they've been ambushed. Remember that notice of application for trial date? You notified them that you will be applying for trial. So they can't say they are not ready. If they do, they must explain why they have not done so in time. Because whoever applies for a trial date has the right to move their matter forward to reach a logical conclusion. Just checking something quickly in the rules here. Now, previously, yes, sir.
I just want to ask something on the trial date issue. Say, for instance, you are applying a trial date whereby the defendant, you've served the summons, you've complied with all the rules, and then there's no response. The defendant was served. You've got the proof of the return of service, and then you apply for a court date. Do you have to notify the defendant?
No, sir, we are not there now. We've passed there already. We need to go back now to summary judgment or default judgment. You are not at trial stage now. We are at trial stage because the defendant has defended the action. Remember, he's filed a plea and the pleadings have closed.
Okay.
It's only at that stage when you apply for a trial date, where he's filed a defendant has filed a plea with a bona fide defense, and you apply for a trial date now because pleadings have closed. If the defendant has not filed a plea then already and he was barred, then you apply for default judgment or summary judgment where he's filed a plea that does not disclose a cause of action. I mean, a bona fide defense. Are we together?
Yes.
Thank you. Now, previously, any party could request from the other party further particulars, starting with the defendant, because the defendant will say, your particulars of claim, I do not understand everything in there, and I want to request further particulars. For instance, what was the age of the petrol attendant? Also, I want to know, did he wear glasses? What is his eyesight like? Those types of questions. They were permitted before, but Rule 16 has since been amended to only provide for a request for further particulars purely for purposes of trial and no other reason. And that is because parties used to abuse the process by asking for, instead of asking for valid particulars, further particulars, they would ask for random things which have no relevance and amounted to a fishing expedition, wanting the other party to disclose their evidence which they intend to lead in court. And those particulars of trial, that request for further particulars may only be made after the close of pleadings now, and not less than 20 days before trial. And only for purposes of preparation for trial. And then The party requested to provide those further particulars must do so within 10 days of being so requested. If they do not furnish it within the 10 days, the other party may apply to court to compel them to deliver those further particulars. Alternatively, they may apply that the action of the plaintiff be dismissed with costs, of course, or that the defense of the defendant be struck out, and the court may then consider it and make the appropriate order in the circumstances. And when the court hears that application for further particulars, the court will consider whether the request is necessary in the circumstances and whether to grant the order as in the circumstances. The court may also refuse to grant them an order to request the particulars because the court may feel that the particulars requested are not necessary, are not relevant, and for that reason, the plaintiff or the party requesting them is not entitled to an order in that regard. Yes, sir. Mr. Marema, your hand is up. Someone's hand is up. Would you like to ask a question? Okay. With your hand down now. Does anyone have a question? Okay, no questions. Right. Now, we come to what is most probably the most important aspect of preparation for trial. But in my experience, the most underrated and discounted process in preparation for trial. Discovery of documents. Now, in the case of Durbach versus Fairway Hotel Limited, a 1949 case, see how far back it goes? 1949, under volume 3, SA Reports 1081, and in brackets, that case was decided in Southern Rhodesia at 1083. Yes, Southern Rhodesia, now Zimbabwe. That's where this case was decided when those cases were still binding on our jurisdiction. The object of discovery was stated as to ensure that before trial, both parties are made aware of all the documentary evidence that is available. By this means the issues are narrowed and the debate of points which are incontrovertible is eliminated. Very simple. To ensure that before trial, both parties are made aware of all the documentary evidence that is available. And by this means, the issues are narrowed and the debate of points which are incontrovertible is eliminated. Now, I said this process I should have said it's neglected by practitioners, because this is the one opportunity that you have as a party in an action to introduce the relevant evidence, documentary evidence which you want to use in trial. And it doesn't just refer to documents. It refers to tape recordings. It refers to CCTV footage. It refers to a police docket, medical records, anything that will support your claim. And remember, after this, the ship has sailed, you have lost the opportunity to make discovery. So you use the discovery process to disclose the documents you intend to do. And how do you do that? You call upon your opponent by way of a notice, and discovery, by the way, is done in terms of Rule 23. In Rule 23.1, you will say to the, in terms of notice, in terms of Rule 23.1, you will say to your opponent, take notice that I'm hereby calling on you. The defendant is calling on the plaintiff to make discovery on affidavit under oath of all the documents, tape recordings you intend to use in support of the trial of this action. And also tell us which of those documents you have in your possession. And if they are not in your possession, tell us in whose possession they are. That's the effect of Rule 35.1. And you must do so within 20 days. So within 20 days, that party must disclose in a discovery affidavit under oath which document it has and which document he or she intends to use at the trial. And most often, parties, I beg your pardon, not parties, practitioners appearing on behalf, acting on behalf of parties, neglect this process. They do not make use of this one opportunity they have to cement and solidify their case with evidence that they intend to use. And this goes to the very heart of your preparation. It will show your client too that you are not prepared, because your client will know when you have not discovered relevant documents. And when your client has to tell you, but I gave you these documents when we first consulted. They are in your possession. And for you not to know at this stage that those are important and relevant documents for my case will indicate to your client that you don't know, number one, your case, because you didn't listen at that first consultation. And it will also tell your client that you are not prepared for this case because you simply haven't bothered to prepare. And you do not want that scenario. You do not want that to happen at all. Now, the party that has been served with this notice now in terms of Rule 23.1 has to provide that affidavit within 20 days. And if that party fails to give that affidavit, and by the way, that affidavit must contain a schedule. The first schedule must contain all the documents relating to this case, and that'll be your pleadings, that'll be your notices, that'll be your reports that were filed. It'll be correspondence exchange between the attorneys, right? That is normally in your first schedule. Your second schedule of documents will contain privileged documents between you and your client. Attorney and client privileged documents. They may also include advices or memoranda from the advocate if an advocate was employed to perhaps give an opinion, or if an advocate is briefed to assist with the trial. Those are privileged documents which the opponent or the opposition is not entitled to. You must disclose that in your second schedule. You need not mention specifically which documents and which memoranda and which advice and which opinions, but you need only say, this is the nature of the documents I have, and they are privileged in terms of, and that's why I'm putting them in Schedule 2. Now, after receiving the notice in terms of Rule 23.1 to file a discovery affidavit, the party fails to file that discovery affidavit within the required 20 days. The party that requested the discovery then writes a letter or sends an email to the attorneys for the other parties to say, we've served you with a notice of to discover last month already, and you had to provide us with your discovery affidavit within 20 days, 20 court days. Those days have now lapsed and you still have not provided us with that discovery affidavit. We are giving you 3 days within which to file it. And if you don't file it within 3 days, we will apply to court to compel you to give us that discovery affidavit. And if they still ignore that letter, which you are not obliged to write to them, by the way, by mere virtue of the 20 days having lapsed and them not having complied, you then bring an application to compel them to give you the affidavit, discovery affidavit. And that application will be done on notice. In other words, it will say the heading, the court, the case number, the parties, and the heading will be notice of motion, or it can even be notice of application to compel. As long as it makes sense and it's a notice. And you'll say, take notice that the plaintiff intends to make application to the above honorable court for an order in the following terms. 1, that the defendant be compelled to deliver his discovery affidavit in terms of Rule 35(1) within 5 days of this order. 2, in the event that the defendant fails to file his discovery affidavit within the period provided for in paragraph 1, the plaintiff be granted leave to apply for dismissal of the defendant's claim with costs. And then 3, that the defendant be ordered to pay the costs of this application. And lastly, further and/or alternative relief. That notice of motion will then be accompanied by an affidavit in support of that application to compel. And therein you will set out the facts upon which you rely for the order. Number 1, this is an application to compel the defendant to file the discovery affidavit. In support thereof, I submit that on the 12th of January, I served a notice of, in terms of Rule 23(1), on the defendants and requesting them to file their discovery affidavit within 20 days in terms of Rule 23(1). The 20 days lapsed on the 29th of January 2023. The defendant refused and/or neglected to file the discovery affidavit by this date. Subsequent to the expiry of the 20-day period, I wrote a letter to the attorneys for the defendant, as a courtesy to request them to file the discovery affidavit in terms of the notice. They have failed to do so. Their failure is prejudicial to the plaintiff, in that the plaintiff is not able to proceed with the case to finality. It is delaying the plaintiff's preparation for trial. As a result, I ask that the court grants an order compelling the defendant to provide the plaintiff with this discovery affidavit within 5 days of the court order. And normally, if those applications are normally not opposed, there will not be any grounds for the defendant to oppose such an application. And the courts normally grant that application if the magistrate is satisfied that the facts are clear and they support the relief sought by the plaintiff in the application. Any questions on discovery?
I have a question.
Yes, ma'am.
With discovery, if the defendant discovers documents after being compelled to discover, but now the plaintiff is under the belief that there's more documents that may be used during maybe trial or in the hearing, is there a way where maybe we could also request that they discover those documents as well?
Excellent question, yes. In terms of Rule 23.3, Sub-Rule 3, you may, if you have information that a specific document is in the possession of the other party, you may send them a notice in terms of Rule 23, Sub-Rule 3, asking specifically for that document. And if they do not have the document in their possession, you will say so in your notice that they must provide you with the names of the persons or the whereabouts of the document whose possession they are in. And if they fail to act in accordance with that notice, you may then also bring an application to compel them to provide you with that document or to disclose the whereabouts of that document.
Thank you.
Thank you for your question.
Advocate?
Yes.
What if the opponent purposely withholds a document and at trial decides to present the document?
They will not be allowed to present that document if they've not discovered it. Sir, we are seeing your face here. Elvin Bavuma. Are you signing the register? Okay. All right. Thank you for your question. If a party does not, by discovery, disclose a document, they may not use that document during trial. And the purpose of discovery is to avoid any surprises. The courts do not take kindly to litigation by ambush. And it is for that very reason that discovery was introduced and it was formalized to prevent exactly that situation.
Okay, Prof. Can I ask something?
Yes, sir.
Who facilitated the pre-trial conference?
Pre-trial conference.
Yes.
We are still coming there. We are getting there soon. You have jumped the gun a bit. It is next on our list.
Sorry.
Okay. No, it's a fair question. I can briefly answer. The parties themselves ordinarily facilitate a pre-trial conference, but there are circumstances that warrant that. For instance, where the opposite party is not willing to cooperate, or that you feel that the issues are complex for the parties to deal with them alone, the magistrate may be requested to convene that pre-trial conference. Satisfied?
Yes.
Thank you, sir. Zanele? Sitole?
I'm not sure if maybe you touched this part, but I just wanted to find out in a damages case, do you only file summons or do you also file like a notice?
Okay, I was coming to your question next. Yeah. In a damages case, do you only file summons or summons and a notice? What notice are you referring to?
A notice, maybe like a notice of intention to defend, or it's just summons and what happens in that case?
All right. Okay. In a damages claim, you have to be specific. What type of damages? If it's damages for a liquid claim, remember the general term damages is in respect of all claims. Claim for damages. Damages could arise from a car accident. They could arise from personal injury, There are just many damages cases. So let's say in a claim for damages for a debt, right? A specific debt, a liquidated debt, a liquid debt. You file summons, you issue summons, first of all. You don't file summons, you issue summons first with the registrar or the clerk of court. But if it's a damages claim for a liquid amount or on a liquid document, you may issue a simple summons. You may also opt to go for a combined summons, which means your summons must be accompanied by particulars of claim, which set out meticulously, systematically, in paragraph form, the facts upon which you rely or want to now set out your cause of action. A notice of intention to defend is filed by a defendant who wants to defend that claim for damages now. So the plaintiff will issue and file summons. The defendant will then serve a notice of intention to defend and file that on the plaintiff's attorneys and file that notice of intention to defend with the court. So the court will know that the case is defended. The defendant will then file a plea, serve the plea on the plaintiff's attorneys, and file that plea with the registrar or the clerk of court, so that the court knows now the defendant has pleaded. Have I answered you, Zanile?
Yes, thank you so much.
Okay. You will see with casework how these things become practical in nature. I've tried in my explanations to you the last few nights to, as practical as possible, explain it to you. All right? But I will provide you during casework with precedents of what these documents look like. We are not there this week, so that's why I don't want to give you, I don't want to confuse you. That's why I'm not giving you these documents this week. But with casework, it'll become more practical. Sipho Simon Msibi. By schedule, do you mean an index? No, sir. I don't mean an index. I mean a schedule. Let me see if I can share something with you. Can you see my screen? Am I sharing something?
Yes, we can see it.
Yes.
Can you see what I'm sharing? Okay, are you happy that I'm
Yes.
sharing?
Yes.
Yes.
Good. Now, this is a discovery affidavit, right? To the gentleman who asked the question about schedules. This is schedule 1, right? You see part 1 says, all pleadings and annexures thereto as between plaintiffs and defendants' attorneys.
We no more see them.
Pardon?
We no more see them.
Opening, say.
Pardon? Is it opening?
No, it's not.
No.
Okay. Let me see if my skills allow me to do this. I tried to in the chat now copy and paste, right? What the schedule looks like. Has it come through?
Not yet.
Yes.
Schedule part 1, right? And then schedule 2 will look something like this.
Advocate, we've not seen it.
On the chat, sir.
There's
Yes.
nothing. There's nothing.
We're seeing nothing.
See nothing.
Yes.
Yes,
There
your
is,
documents are
guys.
not opening.
No, guys, it's there.
No,
It's
guys,
pasted
open on the chat.
Yeah, it's open on the chat.
It's on the chat.
Yeah, on the chat. I've put it on the chat. Okay. So I know some of us are like me, you have challenges with technology. Okay, that's an example of schedule 1. And then I've also pasted on the chat an example of schedule 2. So Mr. Sipo, to answer your question with regards to what a schedule looks like, should it look like an index? It's almost similar to an index, yes, but I've given you an example of what it should look like. Okay, Lebogang, let us say, we are out of time, by the way. Let us say I have received the summons, but then I do not file the notice of intention to defend. Then summary judgment is granted. Can I appeal the judgment? No, sir, you cannot. Summary judgment is a final judgment of the court, and you have to apply for rescission of it, right? Okay. Okay, that then concludes our session for this evening. Right, we will meet again tomorrow night for our last session, and hopefully we'll be able to cover everything. Thank you for your participation, your attention this evening. We'll meet again tomorrow. Good night.
Thank you. Thank you, Advocate.
Thank you.
Bye.
Thank you. Good night.
Thank you.
Thank you.
Good night.
Good night.